Thanks for joining us for this episode, Internal Investigations 101. My name is Raphael Zahardin. I'm a partner at Lewis, Brisbois, Bisgard, and Smith. I'm going to be the moderator today. This webinar is part of the Financial Poise webinar series called Inside Counsel Insider Corporate and Regulatory Compliance 1.0. Slide 8 gives you a summary of the series. Slide 7 summarizes this episode. The episodes in this series and their live debut dates are listed on slide 9. Speaking of slides, you should understand from the get-go, we're not going to step through the PowerPoint. You're not going to have to listen to us read any slides. We try to make this a conversation. And I promise you we'll get out of here within the hour. Keep the PowerPoint handy. It's a great reference source. If I think there's a slide that's out there, we'll try to get to it and bring it into our conversation. But normally, we just don't have time to do that because we're having too much fun talking to each other. Our panelists are John Tang of Jones Day, Pia Thompson with Lawsome GC, Jackie Willett of Mayor Brown, and my name is, again, Raphael Zahardin, and I'm with Lewis Brisbois. So we know that you're not here to hear about us. These aren't infomercials. This is the substantive conversation. You can read more about us, though, if you really like us, on slides 43 to 46. This webinar is production of Financial Poise. You can sign up for the great weekly newsletter at financialpoise.com. You can also shoot an email to info@financialpoise.com. Put in subscribe in the subject line, and you'll be hooked up. If you're attending the live premiere of the webinar, you can submit questions using a web portal. If you're watching this on demand or you have any questions after the webinar, you can send an email to info@financialpoise.com or to any one of us, especially me, and I will connect you. We often do that, and then we talk to people afterwards all the time. Just include your question, the name of the webinar episode, and we'll hunt down an answer for you. Financial Poise webinars are supported in part by sponsors. The sponsors for this webinar are Sunburst Digital, which is the maker of Type to Learn. It's the #1 typing app for children K through 12. Max Asset, if you need to conduct an online auction, Max Asset is a turnkey solution, your turnkey solution. We can read about Sunburst and Max Asset on slide 4. And then also Mood, the nation's premier online retail cannabis dispensary. You can find out more info on slide 3 about Mood. So all the preliminaries out of the way, let's jump into this. So Pia, what types of outside enforcement actions will trigger an internal investigation?
So an obvious one would be a CID, civil investigative demand, perhaps from a state attorney general, where you'd have to start digging in and gathering up documents. It's almost like being served with a complaint. The other areas, would be an enforcement action from perhaps one of your licensing authorities, the CFPB, the FTC, things like that. The one upside, if things come from a licensing authority, hopefully you've seen and started some of your looking into it via your supervisory review. And before an enforcement action came along, you'd at least have some awareness.
Great. And John, are there other ways that internal investigations develop? Like, are there internal sources that might trigger an internal investigation?
Thanks, Raph. There are, and actually, before I kind of dive in, not an infomercial, but I do have to quickly give a disclaimer and say, as I'm sure the audience knows, the views I'm expressing are just personal views. They're not intended to be legal advice, or also not intended to be the views of Jones Day or its clients. With that out of the way, yeah, there are all sorts of internal triggers that could prompt a responsible internal investigation. I'll just tick off a non-exclusive list of some of the most common ones. And those include things like whistleblower tips, or for public companies, things like tips that come in through an anonymous hotline, which could literally be a phone number or a website as intake. There's a few others. For example, if a company conducts an audit, and there's so many variations of an internal audit for various purposes that could surface up an issue that needs to get looked at. You also have employees that raise concerns to their managers or to HR or to management. And then even for private companies, you could have stockholders or venture investors that have a concern that ultimately triggers an investigation. So a lot of different ways this could start off, Raf.
And John, have you ever seen an activist investor do that, or do you think it's contrary to their commercial interest to do that? It sounds like a really good plot for a good movie, right?
Yeah, it does. I mean, so the short answer is yes. Activist investors, as part of their approach, can try a different array of tactics or moves. One of which could be to try to essentially trigger a board's duties to, as they would say, have to look into a particular accusation or issue. So.
Yeah, and I think John's disclaimer at the beginning holds true for all of us, that we're not providing legal advice, and this is just our opinions. And actually, again, we're trying to ground folks into why this area is important. And a lot of these of our series are set up that way. We tell you why, we give you the parade of horrible things that could happen, and then we get into how to manage that. Jackie, on that same note, right? What are some common enforcement and some of the more popular compliance areas that kind of would highlight why this area is so important?
Thank you, Rob, and also thank you for preventing me from having to repeat John's disclaimer, which I was about to do. So, obviously there are many ways many subject areas that could prompt enforcement or compliance issues. I'll take through 4 of the most common ones that we have seen over the last decade. The first, and in no particular order, the first being privacy and data breaches. Yeah. Both the FCC and FTC are actively enforcing this area, with the FCC having established a specific task force. The FTC has recently published data that highlights their actions in this area, to underscore that they have been enforcing this as of lately. And then the states are also very active in this area, with 19 different states having passed their own comprehensive data privacy laws. So as Pia mentioned, this is one area that could prompt a CID from a state attorney general, for example. The second area is environmental impact. And I don't think that in this day and age, there is a single one of these panels that occurs without the term ESG being used. So obviously that is a hot topic right now. EPA obviously involved in environmental impact issues. The SEC, as we all know, has come out and tried to regulate in this space as well, with their recent climate change disclosure proposal. We obviously know the EU is sort of ahead of the US in this regard, and a lot of those regulations do apply to many US companies. And then again, the states are involved here. Specifically California has put out a lot of regulations and proposed regulations. And we've seen, the coastal erosion cases, for example, being one area that they have been involved in. Third is, corrupt and illegal activity. And obviously that is a huge umbrella in and of itself, and can cover, fraud, bribery, and money laundering, kickbacks, false claims act issues, insider trading, mostly enforced by DOJ, some SEC involvement there. We saw FCPA as a big enforcement area. Yeah. In the last decade. That has decreased lately in recent years, but still something companies should be aware of. And then the final area is, what I'll just term, process violations. And these are, you know, things like violations of rules or regulations that are specific to your particular industry, whether it's, you know, FDA regulations, maybe HIPAA is something specific to you. Could also include, you know, disclosure violations, you know, reporting issues, or even accounting errors.
Yeah, and look, I think that the pandemic had a rise in violations that were coming through in trying to speed medical supplies across borders, et cetera. And so while there was a little bit more, I think, FCPA there, I think the FCPA has been kind of ebbed and waned a little bit while the sanctions structure has kind of taken everyone's attention, but that structure is going to remain, right? And so now you're going to have I think a lot of the stuff that's cross-border between what FinCEN is doing and then what the EU enforcement folks are doing is going to facilitate, you know, a lot of, hopefully after the conflict in Ukraine's over, it's going to facilitate a lot of moving back and forth there. Thank you very much. That was comprehensive and helpful. Pia, you know, we've got a lot of business folks who jump on this, and we also have a lot of general counsel that talk to business folks. Can you tell us a little bit about how do businesses, auditors, fraud examiners, how do they kind of define fraud and the types of fraud? Oh, and you're on mute, Pia.
There we go. My anti-interruption button that I always forget to shut off. So there's three big buckets. Some that come, you know, easily to mind: asset misappropriation. So the big one with that is vendor fraud, and we may even know people personally who participated. One of the ways to do that is being a bogus vendor, submitting fake invoices and then sharing it back with the person who paid it. Something that has been the subject of law firms, accounting firms, your coffee vendor, all sorts of things in that regard. That, again, I think is the stuff a lot of people are familiar with. And again, that does involve an element of conspiracy. You're going to need somebody on the inside for things like that. And it's not going to be your biggest dollar hit, but that is probably the most pervasive skimming, fraudulent taking of funds from a company. And that once an investigation is started, the gig is usually up on that kind of stuff, but it can go on for a long time if nobody takes a minute to look into it. Another thing that we see is financial statement fraud. And so a lot of times it isn't just a public company matter. Obviously, for a public company, you're going to do it to hit your quarterly earnings or your annual projections in order to fluff up your stock price. And that is quite a hit for folks, because once there's a restatement, people lose a lot of money vis-a-vis the stock. It can really impact employees whose interests in the company stock might be quite high and perhaps not a balanced portion of their portfolio. So that one's really nasty and hits lots of innocent people. And sadly, while it only accounts for 10% of the type of asset misappropriation we're talking about, it's a very big hit in the numbers and the number of innocents. The last one that's one of the big three is corruption. And so those are the types of things where the financial books of a company is being messed with. Not usually because of money coming in, it's usually because of money going out. And it's going out in bribes to government officials. It is going out in bribes to purchasers. So it's something you have to account for somewhere. Where did the money go? But you can't exactly write down, oh, this was the bribe to the Chinese official, you know, and put it in a lot of detail. So again, you're talking about multiple people involved. And as part of your internal investigation, you know, you're going to be dealing, sadly, with probably multiple levels in that. And then you always have the neat aspect of the plausible deniability of the big guys, right? So where are you dealing with that in your internal investigation, right? Because being the internal investigator can get you in a lot of trouble. And I'm sure that's some other portion of our presentation, but I did want to highlight that with all of these areas, right? The presentation is called internal investigations. So you are dealing with insiders who may have more power than you do. So it's a very delicate thing that is of the utmost importance.
Thank you, Pia. So, you know, again, one of the things we tried to do here is once we've kind of scared you a little bit, we talk about the mechanics, and then we want everyone to go away. We try not to use a whole lot of legalese, but there's certain things in this area that you, in order to talk intelligently with your counsel or to, you know, be intelligent about this area, you got to know about it. And one of those things.
And I did forget one thing.
Sure, go
I'm
ahead.
so sorry. Super quick. I forgot about the money going out of the company because a true outsider stole it. And so internal investigations also have to happen around spear phishing, which is a particular kind of email scam where the scammers can be in your systems for years, figuring out who the players are, how those people communicate, you know, their written cadence, speech patterns, all of that. And then, for example, send an email from the CEO or the CFO to a low-level person in accounts payable saying, I'm the CEO, send this wire right away, you know, get it done. And so that is another way that kind of by definition involves insider action, but not culpability. And so you need to figure out how do you get those people out of your system and things like that. So sorry for the one where I'm not implicating employees of the company.
That's an important subset of misappropriation, and one that I'm sure everybody hears about from their IT and internal counsel all the time. So back to, there are certain areas where you want to have the lingo down, and the Yates memo, or maybe John will tell me that we don't need to know about the Yates memo anymore, but the Yates memo is something that most people know about, and some of these subsequent memos that have come out of justice. So John, can you walk us through what that is, what it means, what's important about these memos in justice?
Sure. So I think it's helpful as a point of historical context to explain some of the reasons why investigations are kind of structured a certain way. That's sort of how I would view the relevancy of the Yates memo to a discussion like this about how to do an internal investigation. Just to kind of cut right through it, though, the Yates memo is referring to a DOJ memo from 2015, I think, from then Deputy Attorney General Sally Yates. And the bottom line is, to sort of summarize it in plain English, what the Yates memo basically said to folks is, hey, if you're a company and you think you might have done something bad or might be accused of doing something bad, and you want to get cooperation credit from the DOJ, you know, for example, for telling on yourself and trying to do the right thing to fix the problem, you must do a couple of things. One is you need to make sure you share with the DOJ all relevant facts. And the most important part of all this is there was an emphasis on including, you know, facts that implicate any individuals that participated in the misconduct. So in other words, what the government was really putting out there in writing is, don't try to protect individuals. We want to, and we require you to make sure you include them in the, quote, all relevant facts that you communicate to us, or else you won't get credit for cooperation. So the memo itself, I think, was titled Individual Accountability for Corporate Wrongdoing. It was really focused on individuals. So that's sort of what the memo is. You know, folks can Google it and read it, but how it really implicates how you conduct an internal investigation and the common challenges that can arise, given that companies that want to do the right thing, want to make sure that they're going to satisfy the criteria that were set out in the Yates memo to get cooperation credit. As you can imagine, internal investigations then should, at a minimum, include looking at whether there are particular people and individuals that are wrapped up in a particular problem or, God forbid, misconduct that the corporation is looking into, and how that can implicate how to do an investigation or challenges that can arise from that, among many other things, are, well, how, as a practical matter, can you get cooperation from the people who are under scrutiny if everybody knows that part of your whole mandate is to see if you need to offer them up to the government at the end of all this? It implicates things like how many counsel may need to be involved. Do these individuals need to get their own counsel? It implicates things like, as we may discuss later on, the so-called Upjohn warning, the sort of disclaimer that's given to a witness by counsel for a company or a board committee that's investigating at the outset of every interview, to make clear that counsel is not counsel for the individual person who's being questioned, things of that nature. So the Yates memo, I think, is quite important as a moment in time that signaled what the government's priorities were in this area. And as a result, it is something that has influenced how you conduct these internal investigations and common challenges that come up.
And, all of these are put together. If people want to review them, they were incorporated into the U.S. Attorney's Manual. There's a section in there where they've talked about the principles of federal prosecution of business organizations. So, and there's some predecessors as well to this. Jackie, let's move on to another memo. So, can you tell us Rod Rosenstein's memo, and maybe talk a little bit about why it was important and what it kind of brought up, and whether it's still valid now too?
Sure. So this is a 2018 memo, and it's addressed on slides 16 to 20 in the materials that you have. And that really goes through it in quite some detail. The way we characterized on the slide, I kind of like the term we used. We used the term carrot. And I think that sort of is a good description for what this is all about. Essentially, the memo, it encourages the DOJ and other regulators to avoid piling on. So, you've seen, when one agency brings some sort of action in a public fashion, many other agencies might then get involved and kind of want their own piece as well. And so this memo really discourages that type of behavior. And it has four main features. It as DOJ obviously has criminal authority, it encourages DOJ not to use the threat of criminal prosecution in order to increase civil penalties. And obviously that is something that, is sort of an ethical issue there. It also encourages coordination within the DOJ components itself. So internally, as well as the third feature is it encourages coordination among agencies. So, between DOJ and other federal, state, and foreign enforcement agencies for, the same conduct. And so encouraging that they coordinate, even if they might have different jurisdiction over this type of conduct. And then the last thing is that it really encourages and sets forth factors for DOJ to assess to assess whether it's appropriate for to assess multiple penalties and when that is appropriate. And so there are a number of factors involved, kind of the common things you would think of, including the egregiousness of the misconduct, whether there are statutory mandates that might help determine this question. This 2018 memo also kind of overlaps substantially with DOJ's corporate leniency principles, which are also incorporated into DOJ's revised justice manual that Rav was referencing. And those principles essentially they allow for the company to receive a presumptive declination of prosecution in instances where they have self-reported and fully cooperated. And it outlines what the company must do in order to receive that presumption. But even if even in situations where there are perhaps aggravating circumstances, and the DOJ does decide to prosecute anyway, there are also substantial benefits the company can receive for sentencing, and likewise, there are also benefits for even if you don't get the declination of prosecution, because perhaps you don't meet all of the different elements to receive that. There's a separate section that allows for you to receive some sort of benefit, to reduce the penalties associated with the sentencing in order, if you have already cooperated, but maybe not necessarily self-reported because perhaps the DOJ found out before you were able to get to them.
Yeah, and it's interesting that obviously the enforcement temperature changes depending upon what's going on in I don't want to say market, but going out outside of justice, and but it's important to follow these letters and follow when someone gives a speech, when the director of the FBI gives a speech to the National Association of Corporate Directors, you need to listen to what they're saying, because they're not hiding what they're going to do. So those are important. So let's get into some mechanics now. Now we've given you some of the folks, the regulators. We scared you. We gave you some concepts that are out there. We talked about some of the players, so what's out there and what to do. The regulatory temperature. So if we want to do an investigation, Pia, how do we set up the framework for it?
So I think one of the first things to do, and this has certainly happened to me, is you need to decide who in senior leadership should be informed. So sometimes the CEO doesn't know about it, and there's a reason that they shouldn't get to know about it, and the investigation needs to go on without certain people at the top knowing about it. And so really think about that if you're the general counsel, head of HR, whatever it is that has come to you. And if you need to seek outside guidance, do that. Because things can get really messed up and you can have an illegitimate investigation if the wrong people are involved. So that should be your first step. Then you really want to have documented protocols for what it is you're doing. And what I mean by protocols and governance is why. Why are you doing it that way? So you should be able to explain the method of your madness. Why is it you're doing questionnaires, or, why is it you're doing phone interviews, or whatever it is. You want to have a timeline, and, it's up to you what you think the optics of that are. Right? You could have a longer timeline to show how deliberate you've been in investigating everything. You can have a shorter one to show how important it was that you got on it right away, right? There's different optics for the way you put your timeline together. So there isn't an overarching, this is the best way to do it. You need to figure out outside folks to come in, and a big thing with that, I think, is how powerful the persons are who are involved or who are being accused, right? So that really comes into play. I think very often at smaller companies where everybody knows everyone. It comes into play when it's a senior member against a different senior member, right? Marketing is accusing engineering of something horrible. So how do you really handle that internally? And how do you handle that internally when you're the general counsel or head of HR who has to work with these two people going forward after? So there are a lot of things that go into the decision to bring in outsiders. And there are other times where, it's not that big of a thing. Just handle it inside, do your paperwork and get it taken care of. And then you've got to figure out privilege and the keeping of documents. So how are you getting people's emails? God forbid you use Slack, which as lawyers we love and we hate, right? All of those types of things. So one of the last things I think is self-reporting. Right. And so that's not usually such a big deal in the HR context, unless I'm sure you're dealing with OSHA or things like that are, physically damaging to people, or there's some regulatory obligation to report those kinds of things. Very often in my world, it has to do with licensing authorities and regulatory bodies. So the CFPB. And those you really have to weigh. And here comes Pia's 2 cents. Self-reporting will be a disaster every time. And it may not be something you can not do, but it will never benefit you, ever. And this because when regulators are ever on a panel, and they are asked at almost every panel, well, do I get some brownie points? Do I get a gold star if I self-report? They will never say yes, ever. They will say the sanctimonious, well, you should be self-reporting. What's the matter with you if you find out something? Why wouldn't you want to come to us, right? So if anyone is giving you the advice that you should absolutely self-report because it's going to make things so much better, that is not true. And if it's been true once, that's just the exception that proves the rule. I'm not saying you never self-report. There are a ton of reasons you have to self-report. What I am saying is the reason is never because you're going to get a bounce, because you won't. And scene.
Well, I think you've got to make a distinction between individual self-reporting and a company self-reporting, because I know that in order to, like, for example, track down some of these cyber criminals, they have said, please, company, come tell me, because the company is not going to be, what you're doing is by not saying something is these guys have now taken down 10 other companies because no one knows that there's a threat out there.
And I couldn't agree more. And I have on more than one occasion when I have been notified of something like that, even spear phishing, our first call is to the FBI. So absolutely. I guess the assumption that belied my point was you found some regulatory violation.
Yeah, I get
and
it.
That kind of self-reporting.
If you walk out of the coffee room with bloody hands, you probably shouldn't call the police. You should call your best friend.
Well, when you call me and it's
And your lawyer.
oxygenated bleach, and I'm sure we got in trouble now with that side comment, but with respect to the what you have described as self-reporting, and I understand the nuance, right? Because you're self-reporting because it could be really embarrassing to your company that something like that happened. I really view it more as calling the authorities, reporting a crime, right? Whereas self-reporting implies that you did something, not that you were the victim of something. But I can see how it could go both ways.
Well, you definitely should tell somebody in your company what's going on, I think, more than anything else, because you can get into more trouble for a cover-up but I get it. I understand your concern. So John, let's say a company tries to gloss over damage and keep it all in-house, right? Which we were kind of talking about, but then figures out, hey, this is more than we kind of bargained for, and I need outside counsel, but they came in a little bit late. What do you have to do? And is there damage there? What can you do to contain the damage? So PNI's conversation, I think, dovetails nicely into your question.
Yeah, and this is for better or for worse, a circumstance that crops up fairly often. I will say, as a career outside counsel, it won't surprise anybody to hear, disclaimer and all, that I always really, really push folks to just ask your outside counsel as soon as you find a problem, whether they think this is the kind of problem where you really should bring in somebody outside, whether it's the high-priced lawyers you usually go to or somebody who's going to be more tailored. If you've got the right outside counsel, they'll tell you straight up, like, whether this is something that they should get involved in, or somebody else should get involved in, or you should just deal with it on your own. What happens, as you were saying in your question, Raf, is sometimes you'll have companies, big companies, small companies, public or private, that just on their own reflexively say, oh, we'll just deal with this. And then you get the call, in your outside counsel office one day when they're deep into it and they've gotten to a point where they realize, oh, this is pretty tough. We need to call somebody now. And obviously, it probably would have been more efficient if, in hindsight, those folks had been helping you chart your course from the get. But what I will say, I mean, there are two things that come to mind. When you have a scenario where a company has, responsibly, with all good intention, tried to handle something on their own, and then it got a little bit too big for them, and then they, at that point, decide to bring in outside counsel. Two phrases come to mind. One is, when life gives you lemons, you make lemonade, right? So on the one hand, you, as outside counsel, you want to assess the situation, figure out if there, in hindsight, were some procedural missteps. Can you somehow turn them into a positive? Can you find the silver lining?
Mm-hmm.
And the other phrase that comes to mind is this idea of trying not to reinvent the wheel, right? Because a lot of companies, that they might have already done some fact gathering, et cetera, and you want to see if you can leverage that instead of starting from square one for all sorts of practical reasons. But I will say that when this has happened, a whole litany of priorities immediately comes to mind.
And something you just said struck me, in that you have to set up a structure in order to be doing those things right, if you're going to do it anyway, and it can't be an ad hoc or organic process, right? But go ahead.
I'll say, that whole, and that's part of the litany of things that immediately comes to mind when you're suddenly brought in midstream and you're trying to assess and diagnose the situation. And one of the first things that will, of course, come up, I know that it's going to come up later in the program, is what, if anything, has happened vis-a-vis the privilege? So, for example, if the company said, oh, we had a non-lawyer, quote, internal audit person who's an employee at the company just do an investigation on his or her own, and he or she investigated and interviewed 5 people with no lawyers around, no lawyers involved whatsoever, there's going to be some potential real tricky issues about, well, could you even say that was privileged? If not, what does that mean? What if we were to do some follow-up interviews with counsel this time, et cetera? So one of those immediate top of mind issues is, okay, what are we working with from a privilege perspective? The other real fundamental point is, sometimes internally at a company, there are politics, probably not too surprising, and there could be ill will, or there could be this view that the investigation should not be trusted for whatever reason. And when you then bring in outside counsel, one of your missions as outside counsel is to try to reestablish the bona fides of the investigation, right? To instill confidence in people, maybe the people who are concerned, that in fact, the right people are here now. We're going to try to make sure that whatever the outcome is, people can at least respect it, whether it's the outcome they wanted or maybe the outcome they didn't. So just trying to reestablish that kind of confidence and trust in the whole process is really helpful and important. And then that whole kind of laundry list of other things like time and money and who are our constituencies and who do we report to, and all that stuff come into play as well.
Thank you. So Jackie, we've just talked about what happens when you potentially have the worst investigation in the history of investigation. What if we want to have the best one? Can you bring some sunshine into the conversation and tell us, how do you set up an ideal investigation once you've got something that pops up internally?
Right, so like Pia mentioned, I think your first question is who do you want to get involved, and who's going to handle this investigation? And that prompts a very commonly dealt with issue, every lawyer's favorite issue in internal investigations, which involves the applicable privileges. So to the extent that that this is an issue that needs to be protected in some way from disclosure, you'll want to get an attorney involved, whether that's an in-house counsel or externally. And obviously, as John mentioned, there are various factors to consider for whether to keep it internal or seek external guidance. Once you have the attorney involved, you will have to make decisions over what can be considered privileged. As obviously makes perfect sense, there's going to be a lot of people interested in the information that is being gathered from the internal investigation. Perhaps it's your auditor that becomes interested. If there is some sort of regulator involved, they're going to want to know what you're finding. It could even be, a nuance of who is the client versus the company. So, for example, if it's the board or the audit committee, or even a special committee that's conducting the investigation, they will be the one that is the client that owns these privileges. And perhaps then when the company, as a separate entity thinks, wants to know some information about what the board or this committee is discovering in the investigation, there are going to be questions of privilege that you have to deal with. So as the slides cover on slide 27 and 28, there are two privileges that commonly come up in this context, and it's the attorney-client privilege and work product doctrine. And these two, they really have different purposes. And I think for understanding the purpose behind them helps us understand the distinction between them. The attorney-client privilege is really the purpose of it is for it to encourage a client to communicate openly with their attorney. And so in order to facilitate that, there is a privilege that protects communications between an attorney and a client when they are for the purpose of seeking or providing legal advice. So in an internal investigation context, you can obviously see that many of the conversations that are being had between in-house counsel, external counsel, and the client related to the investigation, again, for the purpose of seeking or providing legal advice, will be covered by this privilege. The second is work data. Is the work product protection. And, at times something could be covered by both. The work product doctrine usually is broader in its coverage, and it's more difficult to waive it. So work product, the purpose behind that is really to protect the integrity of the litigation process, to prevent your litigation opponent, your counterparty, from being able to obtain information about your litigation strategy. And so in that sense, the work product doctrine will have to relate to things that are created in the anticipation of litigation. The way this most commonly comes up in an investigation is when the investigation is of enough significance that it could relate or impact or result in a civil litigation, or even perhaps a government proceeding, then some of the work product that you're creating could be considered to be in anticipation of litigation. And that work product, can be all sorts of things. It will not cover facts. So to the extent, that you are interviewing witnesses and writing interview memos about those things, the facts you are uncovering will not be privileged, but your mental impressions, the questions that you're asking, the way that you're conducting the interview are considered work product of an attorney. It's also, like I said, more difficult to waive. And so, for example, if you share this information with your auditor, typically it's not considered waived, whereas with the attorney-client privilege, that would be considered waived.
Awesome. Awesome. So, Pia, we've heard about the Upjohn warning. Why is it called the Upjohn warning? And just give us a little historical, and then what is it?
Okay, so it's called the Upjohn warning, which I just think it's a horrible name, so we should change it. But it's
I'm going to say that's the opinion of you, and we're not going to try to offend the Upjohn Corporation or any of its successors
correct.
and other folks. So go ahead.
Correct. And who knows, heaven forfend that's somebody's surname. Anyway, so it was from a court case, and it was I'm sure, and my days of reading it are decades behind me, where it wasn't clear to the executives who their attorneys were, and thought they could rely or get help from attorneys who represent the company. And so I'm sure this is something every one of us on this panel has had to do, which is explain to an executive, and as a general counsel, explain to your boss that you do not represent him, that you represent the company, and that you are always on the lookout for the company. And so this doesn't only come up in situations where there's an investigation and you need to remind someone that they may need to get their own their own attorney, and that they are being represented by company counsel. Let's say perhaps if an employee needs to go for a deposition, but the only reason we're supplying counsel is because we don't think there's a conflict. And you need to make these folks aware that if we do discover there could be a conflict, they're out. They are out on their own. They have to get their own counsel. There are times when the company can pay for counsel. As we all know, an attorney's loyalty and obligations go to the client, not to the payor. So that's another way to deal with the Upjohn exclusion, which is that attorneys in the primary instance represent the company, not any one individual in it. Outside of the investigation context, where I have very often had to give an Upjohn warning, has to do with compensation. And so an executive is pushing for some kind of compensation, and there's negotiations with the board, and I have to tap out. I mean, like, I don't help you with your options or your shares or your bonus. Like, that isn't for me to do.
Right.
And by the way, board, I'm not helping you either, because that's my boss. So that's just another situation where you do need to be very clear with when you're an outside lawyer with your client. And then also as internal, you just need to remind that it's the company and the CEO is your boss, with respect to the fact that that is the embodiment, the human embodiment of the company.
Yeah, and look, that's a lot of the most common standing committees in corporate America are audit committees and compensation committees, right? For a reason, and they're populated with people that don't have any of those conflicts you just talked about. So that's a good way to think about it. So what we're going to do, because we've got about 12 minutes, is we're going to run through a hypothetical to kind of give a little bit of life to some of the things we've talked about. And we're going to look at a data breach and a company that decides to do an internal investigation. So let me try to set the table a little bit, and then I'll let John talk about it. You're going through a work plan, and you interview an IT employee, and you get credible reports that a former employee may have access to the system, and the building for as much as 2 weeks after leaving the company. As you probably know, because it's a hypothetical, although it does reflect life, this is a disgruntled employee because people were laid off, and some of the functions have been outsourced to a company in India. You've got a lot of laptops unaccounted for because there was a mistake in the HR department during the exit interviews, or the fact that there weren't some exit interviews. So what do you do now, John, with that fairly common, kind of hypothetical? What do you do first?
Yeah, thanks, Raf. So just in the interest of time, obviously what we can really kind of dig into in the opportunity that we've got remaining is really going to scratch the surface. No way to be completely comprehensive, but what I would start with is, what are some of the issue spotting that we have in terms of how we would troubleshoot that whole basket of issues that have cropped up. Now, again, the level set, we're assuming a data breach. You're already in the midst of a data breach investigation, perhaps trying to figure out, how was the incursion achieved, was data exfiltrated, all that good stuff. And then in the context of doing that work, all this other stuff comes to light. And so within the context of already all the things you're trying to do to work the data breach, you now have an additional set of issues, not the least of which include things like, okay, so it looks like we might have to at least consider adjusting, perhaps even expanding the scope of the investigation, right? Because now you're going to think, well, now do we need to look into the company's practices about when employees walk out the door and whether they are responsibly having their equipment returned, and B, having their access to the system turned off. So that's sort of a going forward kind of process point. But the historical backlooking issue is, what, if anything, do we need to do as part of this investigation to deal with the people who've already left and look into whether they have data and that whole kind of ball of wax. Two other things that really come to mind right out of the gate. And one is this idea of, well, we've been outsourcing certain functions to a vendor in India. And so that at least triggers two more things. One is the sort of whole cross-border element, right? So what, if any, data do we think we might need for this scoped investigation, let alone some other further work that is housed in India or outside the current jurisdiction? And does that implicate a whole host of, let's say, local law issues and compliance issues that have to be navigated?
It's like a good idea to do the outsourcing, right? And then all of a sudden, everything went awry.
Yeah, and and relatedly, I think companies, of course, need to be reminded that your vendors really should be held to the same standards that you're abiding by, and you need to kind of make sure you keep tabs on that and that you're essentially auditing that. Again, these are all sort of in addition to your scope, which is a common issue that lots of investigations encounter, and that is, how do we stay within our lane? Do we need to take an issue and say, we're going to set that aside and make sure that we come back to it at a later time, or with a different team, with a different budget, or we got to tackle that right now, and here's why, and we need to allocate or pivot our resources, et cetera. Final quick pivot or issue that I'm seeing is this whole issue about HR protocols, right? That implicates more than just the IT angle of what was probably the subject of your data breach investigation. But now you have, as an example, this whole HR process point where you think, well, is there a reason why when people are exiting that for some reason the HR process wasn't as tight as maybe it should have been? So interesting hypothetical that raises a lot of sort of common challenges about what to do with your scope, how far down a particular rabbit hole you should or need to go. This idea of like, let's sort of pull the little string and see where it takes us in a responsible way, et cetera, et cetera.
So thank you, John. So Jackie, to add on to this a little bit, the FTC becomes aware of the breach before the company self-reports, and there's lots of consumers who start calling in with issues with their credit because there's purchases that that are in question, and they complain to the FTC as well. So what does the company need to start talking about as soon as they get the information request from the FTC?
Assuming for purpose of this hypothetical as we have, that there is an ongoing investigation, a lot of the initial scoping decisions will be made. And then at this point, if now there's a regulator involved, I think, some of the primary questions that you're going to have to ask is, how is this going to change or affect your investigation? Does it change the scope of it? Does it change the steps that you're taking? Perhaps you need to talk with the investigator about how they want information, or how they plan to conduct, whether they plan to conduct their own investigation, whether they want to shadow your investigation and receive information through the process that you're conducting. So that would be one of the primary questions that you address at the outset. Another is, obviously we talked about before self-reporting, and this was obviously a context in which there was not self-reporting. The regulator came to the company, so the company needs to consider how that affects their negotiating leverage, how it affects their credibility with their regulator and other stakeholders, and also, how it affects their cooperation credit, and how that might result in what effect that will have on later penalties, fines, and other sentencing. And the company will want to make sure that, to the extent that it can preserve some of the cooperation credit through cooperating with the regulator, they'll want to obviously maximize that. And then, the final thing is, you would want to think about, and perhaps you're already thinking about this as part of your the initial scoping of your investigation, is what individuals are impacted, and what risk is there to individuals from this regulator coming in? Do they now need separate counsel? And start thinking about those issues, because perhaps this entrance of the regulator has changed that dynamic, such that, as Pia mentioned, maybe there now is a conflict, and company counsel cannot responsibly and ethically represent both parties.
And John, is there anything the company can do to be proactive?
Well, I mean, in this particular context with respect to a data breach, obviously one of the things that's top of mind is, what's the best thing to do right by your consumers, right? Your customers. I mean, there's going to be,
because you've got federal law that mandates that.
You have those notice obligations, but I think it's, I would always make sure companies are thinking more broadly about the business, even if you quote technically comply with what the law says you've got to do. I mean, think about making sure you're doing what you can to restore your consumers' confidence, so that you're protecting your brand and reputation and all that other good stuff.
Yeah, you may lose out in the long run. I know that a lot of commentators in the press wrote about they compared Target and Home Depot, and the stock price for Target took a pretty big hit. Home Depot's didn't, because they had data breaches about the same time, and Target was seen or perceived as being evasive, Home Depot a little bit more transparent. And the consumer confidence was translated into that. Nobody wanted to go and buy online or go into the stores because they didn't feel it was safe. So we have a couple of minutes. I want Pia, can you tell me how do we bring this all home in terms of the investigation?
Absolutely. So the first thing that all companies should understand, that it is a massive win to narrow whatever the result is of your investigation. The chance it's going to be zero once the government's gotten involved is slim to none. So you're just looking to narrow. And so fines and penalties, you obviously want them as low as possible. Get your people ready for the fact that it's not the principle of the thing, that you need to get this resolved, and pay as small as you can. You would also like there to be as few things that you agree to as possible. Now, of course, you will pick all the non-monetary things over the monetary things. So do you need a monitor who's going to poke around your company once a month for a couple of years? you really don't want to admit anything, and that one you should be okay. It's the admission seems to be something that goes by the wayside, and that's the one where I'll say pay some money before you admit anything. Try not to deliver a human being up to the regulators. Like, put that toward the end. You don't want to be seen that way, and you want to be careful about forever, making it forever until your company can get talented people again at the high level. With respect to shareholder litigation, you know, you've got some pretty decent defenses, certainly at the board level. I think the last time any board member actually got hit with anything was never, that wasn't covered by insurance. So with that, I'm gonna turn it on to the next point.
Okay. So Jackie, we've worked through a resolution of the investigation, and what do we do now to correct the problem, you know, future or otherwise?
Right, so 4 steps here that I'll cover just quickly. Obviously, you need to remedy this problem, right? Make sure that the bleeding has stopped. Whatever has occurred is now fixed. If that requires a restatement, for example, then maybe, you know, financial restatement, you do that. The second thing is you'll want to look back at the processing controls that you have in place to ensure that moving forward, you know, you're strengthening them as needed, making sure that that things are caught as early as possible. And if there were any gaps in your processor control that may have led to this issue, you'll want to obviously plug those gaps. The third thing is employee issues. If there were certain employees involved, you know, obviously not with the data breach issue necessarily, but in other contexts, if there were employee issues where there was some wrongdoing on behalf of an employee, you know, obviously want to deal with them in could be a variety of ways, whether it's discipline, termination, training. And then the last point I'll make is that whenever you are coming up with your remediation plan, you just want to make sure you have the correct people involved so that, you know, if there's an issue that arose in marketing, for example, you know, we're also talking to accounting about it. So to the extent, you know, accounting has different factors that they're weighing, or also can just be knowledgeable about what has happened here and also take it into consideration moving forward. That's the best approach.
Perfect. John, who gets access to this final report of the investigation?
Yeah, just a couple of kind of considerations to bear in mind, because there won't be a one-size-fits-all answer. You know, who sees it is sort of closely related to what format and how much detail would be in this report. But, you know, the things to think about are, first, internally, who either needs to see it or who should see it. And then, of course, externally, and then I think a close topic that follows on who sees it is how might this report get used, both in an intended way and also in an unintended way. So just as an example, internally, it could either be the board, and that could be split into independent versus management members of the board. It could be management, it could be employees, or the actual target individuals. Let's say they were exonerated, but a particular manager was the person who was accused of something bad and ultimately, let's say, vindicated. You know, would she or he need, or should they see or know about the results, et cetera? That's sort of the internal side. Externally, the list is long, right? It could be your outside auditors, it could be a regulator, it could be, you know, is this the subject of a discovery request in pending related litigation? And that's what really tees up the whole question of how could this report get used? Are there issues of waiver? You know, this is the privilege issue all over again. This issue of the risk of waiver, whether it's intentional or unintentional, and the scope of that waiver, they all kind of inform this really delicate calculus at the end of investigation about what's the format of the report and who should see it.
So have you ever been confronted with a report like this being swept up into a books and records action, for example, in Delaware?
Yes, is the short answer. It could easily become the subject of a 220 demand, and you could tussle over whether it's within or outside the scope and
The scope, yep.
et cetera. Yeah, but it could easily be part of that as just one of so many different hypotheticals that could implicate, again, what's the format of that report? Because you're thinking at the outset that that could happen at the end of this process, let alone who should see it and the implications of revealing it.
Yeah, those books and record demands have increased exponentially. Some of them are related to the traditional shareholder disputes, but a lot of them are precursors to plain old tort actions, consumer-based tort actions, et cetera. And they'll get the information here in Delaware, and then they'll go find another jurisdiction and use that information for their complaint.
Yeah, it's a real tool.
Yeah, and there is some pre-litigation. There is the ability to get pre-litigation discovery in certain states, easier in certain states. I mean, in Delaware, that's what the Books and Records Action kind of is. But yeah, it's an interesting development. Pia, I think we're going to end off with you. So we had this horrible thing happen. It looked like we came out of it because John and Jackie came in to the rescue, and now you're being told, hey, we've heard, Jackie, we know we're going to try to do better going forward. How do we make it stick within the company? And you're on mute.
And I had such a great one-word answer, training. So you have to incorporate it into your onboarding, your annual training, and you have to remember that senior executives and board members have to take the same training as employees.
Yeah, I think it's key in all compliance programs to make sure your top level folks are bought into what you're doing. And if they don't know the mechanics of it, they haven't lived it like their employees, it's not going to work. I'm really happy to you guys joined me today and joined Financial Poise and our audience. This concludes our webinar. Thank you very much for being here. Take care. Bye-bye.